Good evening. The Virginia Supreme Court rules employers cannot fire an employee simply because she's become pregnant.
A divided court voted to reinstate a lawsuit by a Bedford County woman against Scott Gallagher Incorporated. Samara Sodos has the story.
Lisa Bailey lost her job as sales coordinator for the construction and industrial firm Scott Gallagher Incorporated in 1994. She was excused after missing more than 2 months of work during her pregnancy and after giving birth.
When I called him on the phone and talked to him, he told me that I was no longer dependable because I had a baby, that if she got sick, that he would have to let me leave, and he needed somebody more dependable to do the job, and that my place was at home.
Soon after, Bailey sued the company, citing gender discrimination, but a Roanoke Circuit judge ruled Virginia law allowed for the termination. Bailey appealed to the Virginia Supreme Court, and today that court ruled 4-3 in her favor. The court determined that firing employees due to race or gender discrimination is prohibited by the Virginia Human Rights Act. In a majority opinion, Justice Lawrence Kuntz wrote, "Certainly this basis for termination is a classic example of gender discrimination, which is repugnant to Virginia's strong public policy." But in a dissenting opinion, Justice Christian Compton said the majority was rewriting, not just interpreting state law. He wrote such a prohibition might be desirable, but that public policy should be declared by the General Assembly, not for judges. Attorney Clinton Morse for Scott Gallagher says the company was abiding by state law when Bailey was dismissed.
We're certainly not saying that people should not be protected from employment discrimination based on sex or any other invidious reasons. What we do say is that the statutes of this country should be applied in such fashion as they are written.
The lawsuit now goes back to Roanoke for a civil court trial. In Roanoke, Samara Sodos for the Fox 10 o'clock news.